and welcome to Season 5, Episode 6 of ARBinBRIEF, a practical video guide on handpicked arbitration issues. My name is Elizabeth 𝗔𝗥𝗕𝗙, and I am part of the ARBinBRIEF team and practice international arbitration as arbitrator and as general counsel at Toshiba Railway Europe. I have the pleasure of moderating today's episode on independence on trial, navigating conflict of interest in international arbitration, featuring Cecilia Carrara, partner at 𝗔𝗥𝗕𝗏 in Italy, and Catalina 𝗔𝗥𝗕𝗏 Gallego, partner at Wharton in France. You can find further details about Cecilia's and Catalina's practices and expertise in the chat box. Independence and impartiality are fundamental to the legitimacy of international arbitration. But in today's highly interconnected legal and business environment, assessing conflict of interest is no longer as simple as it was. Global law firms, overlapping professional relationships, third-party funding, and the increasing strategy use of arbitrator challenges have created a landscape where transparency and careful conflict management are more important than ever. The modern arbitrator must constantly walk a delicate line between too little disclosure and too much information, where even well-intentioned transparency can occasionally raise more questions than it answers. Cecilia, perhaps we can start with the foundations. Independence and impartiality have been core principles since Roman law, famously captured in the maxim, nemo iudex in causa sua. Yet, the debate around conflicts of interest seems more intense today than ever before. From your perspective, what has changed in recent years that has made conflicts such a central issue in international arbitration?
Thank you, Elizabeth, for the question. I think there are multiple reasons for that. As you mentioned, I would say that the first is the demand from the public opinion of high levels of legitimacy of arbitration. This is a request that affects the arbitration practice and the arbitration market in general, the credibility of the institution, and therefore the standards are set at a high bar. The second point is that there is a never-increasing number of cases. So more arbitration cases, more players involved, with yet a relatively limited pool of arbitrators. So this too has led to a high level of attention to the issue of conflicts of interest. There is also, as a third factor, a demand from the public opinion to have transparency on the conduct of cases, especially involving public parties. And this request for transparency has also led to a heightened level of control over conflicts of interests and has spread in general also to cases between private parties. Lastly, I would say there is an increase in the level of litigiousness of the parties that belong to the arbitration community. So originally it was said and taught in the arbitration courses that arbitration was a friendly way to settle disputes with an expert arbitrator among commercial parties that want to continue to do business together. This is still true, hopefully, but yet there is a higher level of strategy generally in the conduct of arbitration proceedings, which has also led to sometimes use conflicts of interest strategically to maybe put pressure on the arbitrators or overturn some results that are not in the interest of one or the other parties. This trend is reflected in the new version of the IBA rules on conflicts of interest of 2024 that try to balance the needs on the one hand of the parties to choose arbitrators of their choice, and on the other hand to secure that conflicts of interests are taken care of attentively.
Thank you, Cecilia. Now, Catalina, your practice has a strong connection to Latin America, a region where questions of impartiality and neutrality often receive particular attention. Have you experienced that the standards applied to the international arbitration in Latin America vary to the standards they will apply to their own court proceedings or domestic arbitration?
Thank you, Elizabeth. Yes, and I think the variation may be significant depending on the country. So I'd frame it around two perspectives, the perspective of the courts and the perspective of the institutions, which in turn respond to how the courts behave. So on the court side, the general picture is that when hearing an action to set aside an award based on an alleged conflict of interest, courts across the region will typically refer to their own procedural law rather than referring, for example, to the IBA guidelines to interpret both disclosure obligations and the actual existence of a conflict. But to be honest, this is the same in France, where we have the courts applying their own procedural laws. So here there is a tension worth flagging, which is that many arbitrators use the IBA guidelines as the reference when conducting conflicts check. And then the courts will assess those same facts against a different standard. So you end up with a mismatch between the framework that the arbitrator relied on in good faith and the one applied when the award is challenged. But beyond that, there is no uniform regional approach, as I was saying. So you have, in preparing for this session, I came across a decision by the Supreme Court of Lima in Peru, where the court did refer to the IBA guidelines specifically to confirm that a close relationship between counsel for one of the parties and the arbitrators is a circumstance that should be disclosed. So that's the more internationally aligned end of the spectrum. But then you have at the other end of the spectrum, Colombia, where the arbitration statute expressly provides that in domestic arbitration, arbitrators are subject to the same disqualification grounds as judges under the Civil Code of Procedure. And this creates a risk that eventually a court may apply this same framework to international arbitration by analogy. So you have then centers like the Santo Domingo Arbitration Center or the Arbitration Center of the American Chamber of Commerce of Quito that have expressly incorporated the IBA guidelines in their arbitration rules. And we may ask ourselves if this will change the way in which courts will assess specific challenges.
Thank you, Catalina. So, Cecilia, we just heard the different standards that might apply and that some institution, for example, will incorporate ABA and the other will assess challenges based on their own legislation. So what should be an arbitrator doing today when approaching conflict check?
Thank you, Elizabeth. Yes, well, the first thing is, of course, to look at the institutional rules under which it is called to act, if he or she is acting under the framework of institutional rules. And then, of course, to look at the rules of the seat, just in case there would be any particular restrictions other than the rules contained in the institutional rules. If the arbitrator is also the member of a bar in a given jurisdiction, he and she will also have to look into account the professional rules under its own bar. I would say that as a safe standard, one can in general refer to the new version of the IBA rules of 2024 that I mentioned before. That establish that there is a need again for the community to balance the interests of a party to appoint the arbitrator of its choice, who may be the lawyer at a large law firm or employed by a company or another kind of organization, and the importance of maintaining confidence in impartiality and independence of international arbitrators. And then our standard 6 continues to say the arbitrator must, in principle, be considered to bear the identity of the arbitrator's law firm or employer, but the activities of the arbitrator's law firm or employer should not automatically create a conflict of interest. So this clarifies that there is a specific need for the arbitrator himself, herself, to consider, of course, the conflicts of interest potentially that refer to him or her in the personal capacity, but also to look at the conflicts that may pertain to the sphere of the firm or institution that he or she belongs to. Again, what is the relevant period of time? This is also something important that the arbitrator must keep in mind. So conflicts of interest have to be checked anytime that as soon as possible when a request of appointment arrives, but the same kind of attention must be exercised throughout the course of the arbitration proceedings. And again, through practice, this has led to a clarification of the IBA 2024 rules that specify that conflicts need to be checked throughout until the interpretation and correction of the award time limits have expired. By contrast, the IBA rules specify that there is no such duty if the award is challenged pending the challenge of the award. One might, of course, ask oneself if it is indeed advisable for the stability of the award, even during the challenge of the award, for arbitrators to refrain from putting in place conducts that may be perceived as additional elements of conflict.
Thank you, Cecilia. But it seems that there is a lot of things that we should be disclosing when doing this conflict check. So, Catalina, where should a potential arbitrator draw the line between responsible transparency and over-disclosure so that it doesn't backfire?
I think this is one of the most difficult questions, and it's really case specific. I think that in short, the general principle in the IBA guidelines applies, which is when in doubt, disclose. In practice, I think, we discussed this, I think arbitrators tend to calibrate their disclosure differently depending on whether they were approached by an institution or by a party. Disclosing benign facts that clearly don't rise to a conflict may cost you an institutional appointment more easily than a party appointment, simply because the institution is weighing other candidates that the parties have not chosen or even considered. So any factor really runs against you. But my bottom line is, if the situation falls on the red or orange list, disclose, even if the appointing party tells you it's unnecessary, because this also serves a strategic purpose. A party and an arbitrator and everyone that was informed cannot later invoke that same fact as ground for a challenge or an annulment of the award that, for whatever reason, is contrary to its interests. So given the trend that we will discuss, which is towards a more conflict of interest challenges and award annulments in this space, I expect practitioners, institutions, and arbitrators to grow more comfortable with disclosures that previously would have gone unmade.
Thank you, Catalina. And Cecilia, now we have a new trend of in-house counsel serving as arbitrator. And we have also the trend to go to more disclosure, as Catalina just explained. As you know, in-house counsel operates within complex corporate structure, multiple subsidiaries, clients, suppliers. So what do we have here with the conflict check of potential in-house counsel?
Yes, Elizabeth. Well, first of all, let me say that I think it is very interesting that in-house counsel also act as arbitrators, because for sure they bring their knowledge as business operators. So per se, this is indeed something that I think many parties look for, to have arbitrators that really know the business and are hands-on and come themselves from a business background. However, I do think that when it comes to in-house, there is a higher degree of conflicts that usually would have to be checked, because in-house are employees. They have to take into account not just the identity of the employer, and I referred before to the IBA rules, but of course there will have some policies of the group that they belong to, that they have to respect. It is usually the case that groups, especially larger ones, do impose to in-house to stay away from disputes that are in the same business of the group, to avoid issue conflicts, or even to the perception of arbitrators not being impartial and independent in the eyes of the parties, because they belong to a group that operates in a certain field. And of course, checking all the subsidiaries of a large group may be somewhat burdensome. One may ask oneself also if the conflicts checks need to go as far as to verify what are all the suppliers of the group or the most important clients of the group. Of course, this depends on a case-to-case basis, but there are certainly high degree of standards that in-house counsels have to be wary of. This being said, there is clearly an opportunity there for in-house counsel to engage, especially in business areas that are different from the ones that one operates in, and different legal markets.
Thank you. Catalina, so now we have seen that there is a lot of things that we should be disclosing, but we also see more challenges to arbitrators, even at late stages. Do you think that it reflects greater transparency, or are we rather a more of a strategic use of conflict by parties?
I think it's a bit of both, and I think I'm going to echo some of the things that Cecilia said at the beginning. I think that for a long time, arbitration operated as a relatively small club with unwritten professional rules, and repeated co-appointments or arbitrators sitting together multiple times, a limited pool of both counsel and arbitrators. Like, none of these raised eyebrows before. And because of this implicit assumption that everyone would behave. But much of it went unsaid, and I think that paradigm has somehow shifted. And it's something that I would call kind of the democratization of arbitration. So the pool has expanded significantly. We have more lawyers, more arbitrators, more parties from more jurisdictions. And what was once accepted, it no longer looks that way. And the tolerance for close repeated relationships has dropped. We see this directly in the rise of challenges based on personal ties between the parties, or between the arbitrator and counsel for the parties. So yes, there is a more strategic use of conflicts by the parties, but I think there is a more structural explanation, and is that the standards themselves have moved, and we are still calibrating to that new baseline.
Thank you. Thank you so much. And now, because the time is running very, very short, if you could give one practical recommendation to arbitrators conducting conflict checks today, what will it be?
So on my side, it would be keep a personal tracker of all your appointments, matters, parties, counsel, and keep it updated. Conflicts not only surface at the moment of appointment, but this obligation is continuous. And when in doubt, disclose. When in doubt, disclose. That's my main advice.
Good. Thank you, Catalina. And Cecilia, what would be your one recommendation for institutions, parties, and even councils when assessing disclosure or even the absence of them?
Yes, I think there is a division in the roles of the institutions and councils. So institutions clearly don't want to have the arbitrators that they appoint being challenged. So it is a matter of reality that among several candidates, if there will be candidates that have some disclosures, probably institutions will pick those that have no disclosures. So here, clearly there is a tension also on the side of the candidates of maybe not exceeding in disclosures that are irrelevant because they just run the risk of being struck out. On the other hand, of course, what is irrelevant is something that the arbitrators must decide for themselves. So institutions clearly have a duty to protect the integrity of the proceedings, and even if there are sometimes no disclosures, but the institutions know about relations of arbitrators in other cases, in whatever format, because they appear between them. They should remind the arbitrators that maybe they should reconsider their disclosures to make sure that there is nothing that goes unturned. When it goes to counsel, I think counsel usually, if there are disclosures, what I see often is that counsel do ask follow-up questions, and then if they are satisfied with the follow-up questions and they think it is something unmaterial, they just let the issue go. So sometimes, even if disclosure is not relevant, it is important for counsel to secure their client's interest to really check a bit and see whether the disclosure might be problematic or not. So that would be my advice.
Thank you very much, Cecilia and Catalina, for this incredible, insightful discussion and for sharing your valuable and practical inputs with us. Before we conclude, we would like to thank our partner organization, ARBinBRIEF, and the AAA ICDR-Asia Case Management Center for their invaluable support in making Season 5 possible. We are also truly grateful for the many organizations that support the marketing of our series around the world. For those of you that are watching us over YouTube, our video ends here. Thank you for joining us. To see further ARBinBRIEF videos on handpicked arbitration issues, please follow us on LinkedIn and like and subscribe to our channel on YouTube. We would love to hear your comments and feedback, and you can register for our next episode on arbinbrief.com. We look forward to seeing you there.